Number 56, the people of the state of New York versus Eric Ibarguen. Will wait until council have an opportunity to leave.
My apologies, Your Honor.
No problem.
Thank you. Thank you.
Good afternoon, council.
Good afternoon, Your Honor, and may it please the court. Benjamin Welkson on behalf of appellant Eric Ibarguen. I'd like to reserve 2 minutes for rebuttal, Your Honor.
Yes, of course.
In this case, Mr. Ibarguen alleged that he was a social guest having an intimate dinner at his friend's home when the police burst inside unlawfully, without a warrant, arrested him, and then searched the residence. The central question is whether these allegations entitled him to a hearing to determine whether his reasonable expectation of privacy
So let's
was
focus on the
violated.
motion papers. As I read them, it appears that this defendant only made a Dunaway claim in those motion papers. Would you agree with that?
I think, Your Honor, that if you read the factual recitation of the motion, counsel objected to the unlawful entry, which is also a species of search, and it also objected to the unlawful arrest, and also said that any evidence that was obtained as a result, as a fruit of those unlawful violations, would
As
be...
a result of the arrest that he claims was made without probable cause, correct?
I don't read it that narrowly, because if you look at page 810 of the record, the second paragraph resuscitates that the fact that there was an unlawful entry as well, that Mr. Ibarguen was complaining that
Well, I
he was...
guess I'm having trouble seeing how the defendant connects the Dunaway claim and any property that is seized as a result of that arrest to the execution of the search warrant in a third party's home the following day.
Sure. So, I mean, one thing to be clear of, there is some evidence that went in just based on the initial unlawful entry. There was testimony about some of the glass scenes that were found in plain view directly after the entry. So that also it's subject to suppression as a result. But counsel made clear that he was...
What was the evidence that was admitted against him at the trial?
So in addition to that testimony, there was the jacket and there was the $20 pre-recorded dollar bill.
Seized pursuant to the execution of the search warrant on the following day.
Right, but the warrant was incorporated evidence that was obtained as a result of the unlawful entry. If you look at the warrant application, it specifically talks about the glass scenes. It specifically talks about the show-up that followed. And so it's a fruit of the initial unlawful entry, which is what counsel was objecting to.
So does the reviewing magistrate have the ability to excise that information out and make a probable cause determination based on what's left in the affidavit?
I think that is something that the people could perhaps argue at the hearing. It wasn't the basis of their objection below. And so it's open to, to being fleshed out on the hearing. But the cases, there was some discussion of this, not before this court, but in the appellate division. And our response to that before the appellate division was cases like United States versus Murray and People versus Arnow, in which a warrant directly follows after unlawful entry, creates a fact issue about whether or not the reason the police got the warrant was because of the evidence obtained as a result of the unlawful entry, and I think that applies here. It's also important to note that we have to assume on this procedural posture appellant's allegations as true, right? Mr. Ibarguen's allegations. And so from his perspective, he pleads that he's simply sitting there with his friends, having intimate dinner, when the police suddenly burst in out of nowhere. So this idea that the police were following him in and then directly got a warrant afterwards, that's a factual dispute that would be resolved at the hearing.
How do we factor in the fact that the defendant's grand jury testimony was incorporated as a factual basis in the motions and that the grand jury apparently disregarded his grand jury testimony?
It's not clear to me that if the jury disregarded it.
Well, he claimed he was not the seller, correct? And they indicted him for the sale.
That's true. They found that there was, I suppose, there was sufficient evidence to sustain that initial burden. But again, the allegations, including the grand jury testimony, which is part of the record before the motion court, have to be taken from the perspective of the appellant. So they have to be assumed to be true. And in the grand jury testimony, Appellant stated he was there for dinner, he was there the whole night, he received mail at the premises,
Counsel,
and
can we go to that? Because you didn't put an affirmation, right? Your client didn't put an affirmation. It's the grand jury testimony that's the basis for standing, right?
I mean, the grand jury testimony provides a lot of the facts. The counsel did put in his own, like, counsel's
Right.
affirmation based on information and belief, but yes, that's correct.
So I read the grand jury testimony as saying I was having dinner with friends in their apartment. That's the extent, the intimate part with friends comes from, I think, the motion papers. But then the other one is he used the address for his mail because he's always at work when the mail comes and it's tampered with. And I think that was in response to, why did you give this address when you don't really live there? So those two things, under the standard I think that you articulate. But we had a case, Ortiz, which you talk about in your brief, and in Ortiz, where we found no standing, and again, it's a different posture, but I don't think it matters in this context. The undisputed facts were that defendant had more than a casual contact with the apartment, since both his girlfriend and his daughter lived there. And we said no basis for standing. So my question is, are you arguing that because of the Minnesota, those cases from Minnesota in the Supreme Court, this Ortiz is no longer the way we need to approach standing?
No, I don't think you need to go that far. I will note that Ortiz was decided before Carter, so the court didn't have the benefit of Carter when making that decision. But all Ortiz does is an example of this court's limited power of factual review after factual findings made from a full evidentiary hearing. A hearing, I'll add, that Mr. Ibarguen did not get here.
I agree, but the finding was no standing. And we said that was okay, but if we had accepted those facts, right, as found, but still said those were sufficient for standing, we would have reversed. So I don't think the standard there is really what's key.
Well, Your Honor, you did not need to accept the facts that the defendant testified to because there was a hearing. All this court did in Ortiz was affirm the factual finding by the lower courts that Mr. Ortiz had a, quote, relative tenuous ties to the apartment. That's the only factual finding that's made in the opinion.
But based on testimony, as Judge Smith points out, was uncontested that his girlfriend and his daughter lived there.
Sure. So at a hearing, it could be that the fact finder does not find those allegations credible. They could be tested through the adversary process, through cross-examination, and perhaps if Mr. Ibarguen had his chance, he could be believed or he could not be believed. But that's all that Ortiz did. So I
guess the point then would be, at least one of your points, would be we still approach it that way, which is more of a multi-factor test than we just look to see if you're not a trespasser, right?
That's right.
Okay.
Yes. So I know that my colleague on the other side of the aisle does try to paint us as if we're asking for a bright line rule, and we are not. We do believe that there has to be some indicia of connection, and that's exactly what Carter and Olson teach. So Carter and
Okay,
Olson...
so let me ask you this. So I think you're saying eventually to succeed on the motion, you'd have to make that out. Is that the same standard that you think applies for purposes of the grant of the hearing? Because you said the question before us is whether or not he should have been granted a hearing.
Correct.
Is it a different threshold just to grant the hearing?
I think that the threshold to grant the hearing is merely if it frames a factual issue. So I don't think it has to be perhaps as fulsome as what would need to be made out
So you got to
after
have
the
some
hearing.
basis for that. Okay, so is the basis here, I was sitting down having dinner, or is the basis, I leave my mail with them, or is the basis both, or is there something else?
May I respond, Your Honor?
Please.
The basis comes out of Carter and Olson, which essentially made the distinction based on the relationship between guest and host. So there's a spectrum. A business guest does not need privacy, right? Because commercial transactions don't require privacy to be engaged in. In the words of Carter, the defendants were merely there on business premises. It wasn't a home to them. The overnight guest does get privacy because of the nature of the activity. You cannot be an overnight guest unless you feel a sense of security and privacy. And social guests share that same thing because you can't meaningfully engage and be social with your host, unless you
But
feel free.
But doesn't that mean then that if you're invited, as I understood your briefing, you're invited for dinner, that's enough?
I think if the only fact in isolation is you're invited for dinner and we don't know anything else, that would be a tough question. I'm not sure what would happen. The court doesn't need to go this far. But here, you're indicted for dinner, and I use the word intimate because there's only 3 people in the house. Mr. Ibarguen was friends, right? A socially recognized relationship, as this court talked about in Rodriguez, which demonstrates acceptance into the household, right? Because to engage in socially meaningful discourse, one has to be accepted into the household and share the privacy that the host shares with you. Things like worshiping together, talking politics,
So
being
if you had
romantically
never been
intimate.
invited to dinner, this is the very first time, is that enough to get you the hearing?
Yes, if you are invited to dinner by friends,
Yes, I know he calls them friends, yes.
yes, then I would say that's enough. But we have even more here, because the male is also a significant factor.
And then does that, to get the hearing, does that mean that then you, in your view, does that mean that then at the hearing, you have to go beyond that showing? Let's say you established that, invited their friends, I was invited for dinner, it was just the 3 of us. Do you have to go further than that?
I mean, I think that you probably need to show that you were there for some extended amount of time. Here he says the whole night. There could be some exploration by the people about whether or not this is a legitimate friendship. When did you meet? You know, how long have you known each other? That can
And
be hashed out.
would the scope of that privileged status, let's call it, extend to the following day?
I think that it cannot be that the evidence is suppressed because the defendant is arrested and removed from the home, and then as a result of that happenstance, no longer has standing to object. You have to take the evidence found on the assumption that he was there with his friends and the incriminating evidence was in the common area right next to him. It's no different if I come in with a friend, you know, after a political rally, and I bring some pamphlets with me, and the police all of a sudden burst in, disrupt our conversation, and start rifling through my political pamphlets. Under the people's theory, I would not be able to object to that, and that can't be right for a free society.
Well, if he still had the standing to object, then why didn't he somehow attack the probable cause that led to the warrant as opposed to challenging his arrest, which is what he did in his motion at 810?
He did challenge probable cause for the warrant, Your Honor, because he specifically said, I was in the house the whole time. He denied having any engagement with the drug transaction. He said, I wasn't there. I had nothing to do with this. They were looking for some other guy.
Counsel, was there a motion to controvert the search warrant?
No, again, but that's because his objection was to the unlawful entry and to the fruits that were derived from the unlawful entry. So
Can I ask a follow-up question on the pleadings? Because under Mendoza, do you think you satisfied Mendoza with those allegations? You've given us a lot of facts, but the pleadings were very bare-boned and conclusory. So how are we supposed to view that in light of Mendoza, which says basically that the defendant is the person with the information? He has it, he has to put it on paper so that he can meet his burden, which is a heavy burden under Mendoza and Burton, to get that hearing. How is that satisfied here?
I think it's definitely satisfied under Mendoza. I want to push back a little bit on the characterization of a heavy burden, because all we have to do is frame a factual issue that survives summary judgment. But here, in Mendoza, if someone who was arrested on the street and claims that arrest was illegal, all they have to say was, I was doing nothing wrong on the street. We're not talking about the buy and bust, right? We're talking about just all of a sudden arrest on the street. I was doing nothing wrong, and the police say, yes, you were. That's a factual issue that's in dispute. And here, the factual issue in dispute is whether or not he has a connection to the residence such that his reasonable expectation of privacy was impaired
But both
upon.
Mendoza and 71060 asked for sworn factual allegations, and what's in the motion is this legal term of art, lawful invitee. And there are numerous cases that stand for the proposition that lawful invitee doesn't give you the expectation of privacy that you're arguing for today. So the question arises, why not say guest at dinner instead of lawful invitee?
Well, I will concede that, defense counsel could have been a little bit more fulsome in his original motion, but he referenced the grand jury testimony, and the grand jury testimony was before the motion court. The people understood what the significance was. On page A16, they say a person who is over for dinner with friends who receives mail at the premises is not entitled to a reasonable expectation of privacy. So that fact issue was clearly put before the motion court, the exact same thing we're arguing now. And the motion court denied the motion based on that record. So I think it's clear the facts were purely put forth for this resolution to be made.
Counsel, I have a question, and it's not this case, but, just looking at what our rule might be or how we might approach it, and I'm curious about how you would approach it. So, let's say, different scenario, the affirmation comes in, I go to dinner regularly, I'm a guest, I've known these people a long time, I'm in the dining room at least once or twice a week. While the defendant's in the dining room, the police come in with a search warrant, they search the office, seize a computer, and on the computer is evidence of the defendant's commercial fraud. Standing to challenge the search of the study?
Yes, so I think that's a different case. I mean, I think the guest in that, the usual social guest probably doesn't have access to the computer in the study, so unless they have some pleading or some showing to show that they, regularly use the computer and therefore had an expectation of privacy, it's really no
Let's say it's in
different.
the desk. Maybe computer's a bad example because it's a little
Sure.
bit different, but in the desk. So I guess the bottom line question would be, would there be some limit within the residence as to what you would have an expectation of privacy, or is it, anything there once I'm in that dining room regularly?
Yes, so, okay. I think as a guest, you have the right to object to the entry and what's derived as a result of the entry, because you have the right to feel
Which
secure.
I understand is your argument here.
Right.
I understand that.
In terms of the search, I think that our rule would realistically be the guest can object to, the common areas where the guest has access to typically, which would include the bathroom, which is where some of the evidence was found here. I think that I would have a harder case if it was a study, because that's like ruckus, right? That's the casual, quote-unquote, casual visitor, which really the court was trying to express the fact that the person who doesn't have, the guest who's never in the basement doesn't have a reasonable expectation of a search of the basement. And so that, I think, would be more along the lines of the question you're asking.
Thank you, counsel. Counsel?
May it please the court, John Castellano for the Office of Melinda Katz. Your Honors, in this case, these pleadings were the barest of bare bones pleadings. At no point does the defendant even cite Peyton. At no point does he move to controvert the search warrant that was obtained after the people entered.
But counsel, isn't his argument in fairness, and maybe it's not the most artfully drawn, motion paper, but you came through the door, I understand you dispute this, but you came through the door, it was an illegal entry into this apartment, you saw heroin, you used that to get a search warrant, it's the fruit of the poisonous tree.
I understand the allegations, but in fact, he's got to state under 71060 a ground for relief. He never even invokes Peyton as to the unlawful entry itself. Never cites any cases for that matter. But just if the factual scenario alone is enough to preserve it, we've really gone a long way from at least having to make some type of legal argument in support of his ground.
But why aren't those facts enough, if true? That he was there for a social purpose, he receives mail at the location. Why isn't that enough for a hearing? And why wouldn't the better practice just be to grant the hearing?
Well, as Your Honor indicated, you have to judge the sufficiency of the allegations in support of a motion by not only by what the defendant says, but by what the defendant could have said in light of his access to information. In this case, the defendant had ample access to information about the premises where he was arrested and could have made allegations with regard to the multiple factors that this court specifically pointed to in People v. Rodriguez that laid out the test there, and multiple factors that other courts have looked to both before and after the Olson and Carter decisions in determining whether or not the defendant has standing. That includes, for example, whether or not the defendant ever, at any point in time, stayed overnight. That fact alone distinguishes this case from every federal case that the
Yes, but
defendant
he's
relies
not-
upon.
He agrees with you on that. He's not making that argument. That's not even in dispute. There's no assertion, and he makes none that if that were the case, he should have gotten a hearing. His whole point, the only reason the case is here, is because no, he's not staying overnight, hasn't stayed overnight, and never made such assertion, that he's just there for dinner, and the people who live there, he has an arrangement with them so that his mail is delivered there. That's it. What else did he need to say other than cite cases?
Right.
To get a hearing, what else did he need to say?
What he needed to say is he needed to allege some measure of control of the premises. And the reason that I say that is because in Olson, when Olson is talking about...
What does that mean, measure
sorry?
of control? I want to know what that means, measure of control. You're a guest. What kind of control does a guest have?
Well, an overnight guest, according to the Supreme Court in Olson...
But he's not an overnight guest, so that's
Right.
the question. You could certainly take the position that nobody but an overnight guest can have standing. I don't know if you're going to win on that, but if that's your position, that's your position. But if you're something short of that, then what does that mean, control?
What that means is that some access to and expectation of privacy in the premises as a whole. So if I'm an overnight...
The premises
I'm
as a
sorry.
whole, or the areas that are, as he argues, common, the typical ones? The basis here is, I had dinner there and I leave my mail there.
The premises as a whole. And the reason that I say that is because if you take a look at Olson, and there's really only, Olson is the central case here, because Carter is a case that denies standing. So if you take a look at Olson and you look at what it deems to be legally significant about an overnight guest, what it says is, in part, there are two things, but one of them is, when the host is asleep, the guest effectively has unrestricted access to the premises. They say that. It's unlikely that the guest is going to have any restrictions as a practical matter on their conduct. And as a result, they have what the court describes as a measure of control over the premises. That's exactly the phrase that they use, a measure of control over the premises.
So then, is your position that the Supreme Court has said the only people who have standing are those who are overnight guests?
No, absolutely not, Your Honor. But you have to elect...
So now we're short of that.
Sorry?
So if you're short of that, I'm trying to ask you to please address what you mean by control when it's not an overnight guest. If you are, again, if your position is you got to be an overnight guest, so be it. If that is not your position, you just said so, then what would be the kind of control a social guest would need to have?
A social guest would need to have, or need to allege in this case, in order to obtain a hearing, that they had access to, or control over, but at least, at the very least, access to areas of the premises that an ordinary social guest wouldn't have. So if I'm sitting down for dinner with somebody, that doesn't necessarily imply that I can go wandering into the bedroom, or even that I can go wandering...
They're only asserting the area where he's having dinner and the bathroom.
I'm sorry?
They're only asserting the area where they're having dinner and the bathroom. They're not talking about any bedrooms.
Right, absolutely. Yeah, I
And
understand.
would a person who's invited for dinner, who says they also leave their mail there, but I'm happy to stay with just the dinner, would that person have control, under your scenario, of where they're seated for dinner, that immediate surrounding area, and the bathroom?
They have, just like anybody who's legitimately on the premises, they have an expectation of privacy in their immediate area, in their person, in their clothes, in any belongings that they brought, in their grabbable area. But that doesn't mean they have an expectation of privacy in the premises as a whole. And that's what's really key here, and I think that's what the Supreme Court is getting at in Olson.
I misunderstood you. I thought you were saying they would also have control over the immediate area where they're located and any other area that one would deem reasonable for a guest to have access to. So I misunderstood you then.
A guest has, as I said, I think an expectation of privacy in that immediate area, but not an expectation of privacy in the premises as a whole. And I think that's what's key. I think that's what the court's getting to.
Let me ask you hypothetically, if the guest arrived at dinner and the host said to him, dinner will be ready in a minute, why don't you leave your jacket in the bedroom, put it on the bed, and we'll start eating right away? Would that give you a measure of control over the bedroom?
No, I don't think it would, Your Honor, and I don't think that would be even enough as an allegation, because what that is saying is there's some level of access, but there's no real expectation. I don't expect that I'm going to be able to, for example, exclude others from the bedroom, or to have any say in who comes and goes into that bedroom. Maybe every other guest who comes, I say, why don't you go into the bedroom and leave your jacket there? So there's really no inference or necessary inference of an expectation of privacy in the bedroom under those circumstances.
Well, in that example, the access is limited. It's for a particular purpose, not for anything else.
Exactly, for a particular purpose. It's not the type of general expectation in the premises itself that I think the court is getting to, and I think in Rodriguez, for example, a lot of the factors that this court elicits or lists have to go to the interest in the premises as a whole. So in other words,
So
when
when you say, just to be clear.
Sure.
Premises as a whole, let's say it's an apartment. You mean the entire apartment, every part of that apartment? Is that what you mean?
Well, I mean more than 1 or 2 rooms. So, for example, yes, you'd have
Well,
to
then
have...
that would mean that every dinner guest, unless their host walks them through parts or says to them, you've got free reign, would never have standing.
There are many different types of dinner guests, right? You could have somebody this is their first time, and as far as we know in this case, he doesn't allege he was ever over there any other time as a dinner
Correct.
guest.
You're
If you're the 50th time there as a dinner guest and you've gone into the bedroom before and you've taken a nap there or you've been alone in the apartment there before, which are all factors that all of these courts look to, that would be different, right? If you're alone on the premises...
Why isn't that something to explore at a hearing?
Yeah.
Because you have to establish in the first place under 71060 the factual allegations that make out your entitlement to relief. And he does not make any allegation and go through all of the other allegations.
What if he said I had access to where we were sitting, the bathroom, and the bedroom? What if he said that? And the kitchen? I went up and got a bottle of wine.
I'm sorry,
What if
which
he
ones are we talking
asserts
about?
that? Is that enough to get him a hearing?
No, absolutely not. If he said, on the other hand,
Okay.
50...
Why
if
why
he's-
not? Why
Sorry?
not?
Because it doesn't show that exercise, either that measure of control over the premises, or even that access to the premises as a whole, or that interest
You
in the
mean
premises as a
because
whole.
it's a conclusory, self-serving assertion? Is that why?
I'm sorry?
I'm saying, if he asserts, I was sitting at dinner, I had access, my host told me, I have access to the bathroom, I went into the kitchen, I had access to the kitchen, I also went into the single bedroom that was located. If he said that, does that give you enough for a hearing?
I'm sorry, did you say to the single bedroom?
Yes, say there's only one bedroom. I mean, there's 2 people, I'm going to assume there's one bedroom.
If he said he had access to all of that?
Yes.
And we're talking about a single night guest? Potentially,
Well,
I
dinner
suppose?
guest, I didn't say they were staying
But
overnight.
enough-
Again, that's not the question on the table.
I'm sorry?
It's just a dinner guest.
It's a dinner guest, a one-time dinner guest, who's told that they have access to the entire apartment.
Yes, that's his assertion.
Right.
Would that be
I
enough to
guess
get
it
you a
would-
hearing?
I guess it would depend on who else is in the premises and has that type of access. That would affect your expectation of
But why
privacy.
does it matter if the host is telling you you do?
I'm sorry?
If his assertion is the host told me I could go into each of those rooms, why does it matter if the host tells anybody else they can?
Because that affects your expectation of privacy there, right? If it's a party and there are 30 people in the study or whatever room that we're talking about, your expectation of privacy is affected by who else is present. So, and this idea, I know that the defendant kind of disavows this idea that a social guest automatically has an expectation of privacy, but it's in his brief, it's in his main brief. I can cite to 7 different places where it is. It's in his reply brief. He says the determinative factor in the test is whether he is a social guest. In fact, he says all 9 members of the Supreme Court have decided that the determinative factor is that whether you are a social guest. A social guest rule would be contrary to both the reasoning
Well,
and the
let's say we
results of this court.
disagree with him as a per se rule, but
Sorry?
that, as he conceded earlier, I believe in response to a question from Judge Garcia, that it is a multi-factor test.
It
But that
abso-
his point is merely concluding, oh, you were a social guest, or you were a casual visitor because you were a social guest. That's where he says that's the per se rule in the other direction, and that's not permissible. This is a multi-factor analysis, and I think you're agreeing that you're looking at all of these factors, what's access, what's control. So if we're both sort of in the same ballpark there, what is it that's missing from his motion?
What's missing from his motion is any allegations with regard to those factors in Rodriguez and those other
Okay.
factors that the other courts have looked at, like was he ever there overnight? Was he ever there alone? What was his access to the apartment in and out? Did he have a key? Could he even come over unannounced, for example? What was his access when he was inside the apartment? Could he deny anyone access to the apartment? Could he exclude anyone? Did he ever ask to exclude anyone from the apartment? All of those things. And more important, just finally, if I may, the mailbox issue, getting your mail there. In this case, in an ordinary case, it might be important because it would be an indication that the person resides there, at least part of the time resides there. In this case, the defendant specifically disavows that in his grand jury testimony. So he says, I do not live there. As an accommodation, he never tells us when he goes there to collect his mail, does he put his hand in the mailbox and fish it out? Does he go to the front door? Does he ever cross the threshold? If he crosses the threshold, is it for 30 seconds or 30 minutes? He never gives us those answers to those questions.
But don't those sound like good reasons to have a hearing?
Those, in the first place, what he has to do is establish that entitlement to relief. And all he's done is said, I go over and I pick up my mail there. So as an example, if I get Amazon packages every day and people are taking things off my stoop, and therefore I go to my neighbor and I say, you've got a fenced-in yard, so could I have all my packages delivered to you? And they say, absolutely. That doesn't show that I have an expectation of privacy inside their premises. There's something that's fundamentally lacking there, and that's what the problem with the defendant's pleadings are in this case.
But it does suggest a relationship with the homeowner, and that's something to consider. And again, why doesn't that get you, as Judge Wilson was asking, get you past that hurdle, just to a hearing, not the ultimate conclusion, just for purposes of a hearing?
Right. It doesn't get, well, first of all, again, he's got to establish that entitlement to relief to get the hearing, to be entitled to the relief, to be entitled to the hearing in the first place, right? Like I say, in the absence of all of these factors or any indication as to all of these factors that would actually show an expectation of privacy inside the premises, his pleadings were not sufficient. They were the barest of bare bones, two-sentence pleadings that did not make out his claim.
Thank you, counsel. Counsel?
Your Honor, the people's conception of the test is far out of step with jurisdictions throughout the nation and legal commentators. The test is not measure of control. It's about our reasonable expectations of privacy. Overnight guests have them because the nature of the activity of sleeping overnight requires that they be able to feel secure, and they have a sense of privacy, and that they therefore expect the host is sharing that with them. The same is true for social guests. Think of the home. The home is the place where we can retreat to be with ourselves, but it has a broader function. It is the place, perhaps the only place, where we can be together with our chosen intimates.
No, but he does have a point, and I believe Judge Singh has asked you about this before, that the strongest facts that would be in favor of your client are solely within the knowledge of your client. This is the person who knows the nature of the relationship with the host. This is the person who knows whether or not the host said, you can go here, you can go there, you can do this. This is the person who knows whatever arrangement he has with those people regarding the mail. He knows where the mailbox is located. He knows if he's ever gone into the house, if his arrangement is, I get home late, please take it out of the mailbox, hold it inside, I'm going to come in and chat with you about it. He's the one who knows all those things. And everybody's very busy, I get that. It is a few sentences more in the motion. Why does that not carry the day, even for a hearing, just for purposes of getting the hearing?
Because the issue is whether the pleadings frame a factual issue, whether it can be determined as on summary judgment that there's no possible way Mr. Ibarguen had a reasonable expectation of privacy. And here, being with friends and sitting down to a meal. Think about a meal. When we're eating together, you know, it's the way we get to know each other. It's the way we celebrate our connections with people. And I also want to touch on the mail. The mail is a significant factor here because, first of all, storage of possessions at a place is regularly relied on by courts to demonstrate a reasonable expectation of privacy. But mail is very powerful because there's a lot of sensitive correspondence that we receive and we get in the mail.
Yeah, that was an interesting point you made. What about his point that there has to be an expectation of privacy in the whole area?
Yeah, to be honest, I'm not exactly sure what that means even. The point of the reasonable expectation of privacy is that can you enjoy the host's company? Can you be social with the host and not expect someone to burst in and disrupt you? I think we all would agree that if we're sitting down to dinner with friends, we don't expect that to happen. We don't expect the police to burst in all of a sudden and start rifling through our papers.
But that even under your theory wouldn't be enough, right? Or you're not arguing that's enough here. You don't need to. But if you just said I was sitting down to dinner, the police burst in, no mail, that's just I'm not trespassing kind. I mean, I'm having dinner, but I was an invited guest rule.
Sure, I think the mail is very helpful to us. It would be a tougher case without the mail. In our view, I think that if sitting down to dinner with a friend and I was there all night, I think is still enough and certainly enough to satisfy the threshold requirement for a hearing.
Now, if you alleged I was sitting down to dinner, and this goes to, I think, some of the questions my colleagues are asking, if you just put in an affidavit saying, the client says, I was sitting down to dinner, is that enough to get you a hearing so we could explore the dinner?
I think that fact in isolation is probably not enough, but the collection of sitting down to dinner with a friend, there the whole night, I live down the block, I receive mail, which probably means I'm over a lot, that's enough. And I think if this court and the Supreme Court both recognize that we have a reasonable expectation of privacy in our public movements, right? Because they give a window into the intimacies of our life. And the same exact logic holds here, because the home is the place where we can have those privacies. We can be together. We can talk politics. We can worship together. We can be romantically intimate. And if we impair the ability of the home to be that space for us where we can share our intimates with each other, then we have significantly impaired the ability of the home to be that pinnacle of privacy that the Constitution expects.
Thank you, counsel.